Will I owe money after foreclosure in California? As an attorney, this is a question I get asked a lot, and one that brokers and agents are often unable or unwilling to address. The answer to this question, as is the answer to many complex legal questions, is maybe. This video is not meant to be taken as legal advice and should not be relied upon as such. There is no substitute for an actual consultation with an attorney. The intention of this video is to offer consumers some basic information to allow them to better understand their situation and, if necessary, to have a more meaningful consultation with legal counsel. In California, there are two entities that may be owed money after a home is foreclosed: the mortgagor and the government. This video focuses on money that may be owed to the mortgagor. Please see our video on tax implications of short sale and foreclosure to better understand if you might owe money to the government. It is first important to understand that California is a state that allows for non-judicial foreclosures, and almost all foreclosures in California are non-judicial. Non-judicial means that the foreclosing entity is foreclosing directly under the terms of the contract and not through the judicial system. A major distinction in the law is owner-occupied versus non-owner-occupied properties. Two sections of the California Code of Civil Procedure are very important to understand. Those sections are 726 and 580. For a more detailed discussion on 726, referred to as the One Right of Action Rule, and 580, California's Anti-Deficiency Law, please see our videos on these topics. 726A makes no distinction between an owner-occupied property or a non-owner-occupied property. It simply states, in short, there can be but one form of action for the recovery of any debt or the enforcement of any right secured by a mortgage upon real property or an estate for years therein. Basically, a foreclosing party who elects to foreclose non-judicially waives their rights to a second remedy, i.e., a judicial remedy or money judgment. They get the home, and that is all. They cannot seek additional monies even if the home is liquidated for less than the loan balance. If this is a commercial loan and there are personal guarantees, the issue becomes more complicated for the guarantor, and that is beyond the scope of this video. Understand that 726 only limits the rights of the foreclosing mortgagor and does not limit the rights of other mortgage holders. To determine if a non-foreclosing party can seek a deficiency, one needs to examine California Code of Civil Procedure 580. Most importantly, 580 subsection B, as in boy. In short, if the loan in question is a purchase money loan and is for an owner-occupied 1 to 4 unit dwelling, no deficiency will be obtained. So what does all this mean? If I lost you earlier, this is what you need to know. Purchase money loans for owner-occupied 1 to 4 unit dwellings will result in no deficiencies being owed. So one only needs to be concerned with non-foreclosing mortgagors holding refinanced loans, often those in second, third, or subsequent positions. For non-owner-occupied dwellings, any mortgagor who is not the foreclosing party may seek a deficiency, or if in the unlikely event the foreclosing party is seeking a judicial foreclosure, then the foreclosing party may also seek to recover a deficiency. I hope you find this video helpful, and I hope you explore opportunities to investigate our other videos